Okay, once again, good afternoon. My name is Kevin McKeon. I'm the Deputy of Assessment Administration, and with me is Alex Luca, who's our legal counsel here at the Property Appraiser's Office, representing Mr. Mike Twitty. Thank you for joining us. Happy New Year to all. This is our first session of 2023, and I invite you to go into the chat box and type in questions as we go. I mean, I'm happy to answer them as we go, any question you may have. So we'll get started with Homestead Exemption and Save Our Homes Cap. A little bit of the history of the Homestead Exemption. Back in 1934 was the first Homestead Exemption in the state of Florida. It was at $5,000. It moved to $25,000 in 1980. And then again to $50,000 in 2008. But the real benefit to Homestead, which we'll talk about further, is the Save Our Homes Amendment from 92 to 95. That is a huge benefit to Homestead, especially in a rising market like we've had in recent years. So the Homestead exemption is actually in two tranches. The first exemption of $25,000 applies to assessed value of property between 0 and 25. There is no exemption for assessed value between 25 and 50. And then the second 25 kicks in between 50 and 75. And that 25 applies to all millages except school. So school millages only have a $25,000 homestead exemption. Anything above 75, there is no homestead exemption. So it is 50,000, but your assessed value has to be above 75 to get the full $50,000 benefit from the exemption. So the first and second homestead exemption combined, depending on where you live within Pinellas County, there are various millage rates in various municipalities where you live. It saves you between 500 and 1,000, 500 being in the lowest millage rate areas and 1,000 being in the highest millage rate areas. Now, the Save Our Homes cap limits your increase of assessed value once you've established homestead. So the first year after you've established homestead, for instance, if some of you who are participating today, your first year is 2023. 2024 will be the first year your assessed value is limited to the lower of 3% or consumer price index. The main qualifications in order to qualify for homestead is you must own and occupy on a January 1st. So if you just recently purchased a home, let's say yesterday on January 11th, you are not eligible for homestead till January 1 of 2024. You must be a permanent Florida resident. And the gating items that qualify you for that are a Florida driver's license, registering your car, are the two main. And you can only have one homestead per person or marital unit. So if you are married, both you and your spouse can only have one homestead exemption. You can't have two. You can have no other residency-based exemption anywhere in the world. I say the world because there are residency-based exemptions in places like Puerto Rico, for instance, and the British Virgin Islands. So if you have a residency-based exemption in another state, you will not qualify here in Florida unless you remove that exemption. And a corporation, a corporate entity, does not qualify for homestead. It has to be an individual or a trust, which we'll get into later, and Alex is part of the presentation. I wanted to show this to you because in about 3 weeks, a little over 3 weeks, You will receive, if you have homestead, meaning if you have a homestead exemption that existed 22 and prior that rolls into 23, or if you have already applied for 2023 and we have approved your homestead, you will receive this notice. This is a notice that our office does as a courtesy. It is not required by law, but we give you an opportunity every year to let us know, to number one, we give you an opportunity to let you know you have homestead for the upcoming year. And it gives you the opportunity to let us know whether there have been any changes in your status. There are certain changes in status that may affect your homestead or may affect your ability to keep your homestead. You may, and here in this section, the bottom part, right below this, you have an opportunity. Let's say you got married. You need to let us know that because we need your spouse information. By law, we have to have both spouses' information if they are married because they're only entitled to one homestead. Maybe one of the owners of the property is deceased. Maybe the only owner of the property is deceased and we did not know about it. You need to let us know that because that affects your Save Our Homes cap and the homestead exemption. If you're 65 years or older, you may qualify, and a low income senior, you may qualify for an additional exemption. So if you turn 65 in 2022, you may be eligible for a senior exemption in 2023. So this is your opportunity to let us know whether anything about you has changed. You may have already sold it, which we will eventually get the information that you sold it, but it's okay to tell us that you did. You may have decided you wanted to move to another state and rent your property. You need to tell us this information because it could save you a lot of heartache and penalties down the road. The other important notice that we send out from our office, and I believe this is the most important notice, is your trim notice. Those of you who have had homestead before, everyone receives these, whether you have homestead or not. This is your estimate of property taxes for the upcoming year. These are mailed out in August, in late August of 2023. And this has a wealth of information to let you know about the market value of your property, the assessed value of your property, and the taxable value. In this section right here at the top, the blue section, this year 2022, you can see there's market value, assessed value, and taxable value. The difference between market and assessed is your Save Our Homes cap. This is a longtime homesteader who has been here a long time and has built up well over almost $245,000 of cap. That is the Save Our Homes cap. And if you have homestead, you will see that 50,000 reduction in taxable value. If your taxable equals assessed, you don't have a homestead exemption. So pay attention to this. If you've applied or you thought you applied, you still have an opportunity when you receive this notice to apply for homestead, but you only have about 25 days. And if you miss that window, you have to wait to the following year. And school districts, as we pointed out earlier, that's only a $25,000 reduction because that second 25 is not applicable to schools. You can always get your trim notice from this year or prior years by going to our website at www.pcpao.gov. Go into your property, click on the trim notice, and we usually post these trim notices before they are mailed. So you'll be able to see them when you go in sometime around the third week of August before you even receive them in the mail. They're always there. So if you miss a mailing or it gets thrown out inadvertently, you can always go to the website and print it out for yourself. Let's move into the Save Our Homes cap. The history of Save Our Homes. The Lee County property appraiser back in 1992 notice that values were skyrocketing here in the state of Florida back then, and a lot of longtime Floridians were being priced out of their homes. So he proposed an amendment to limit the assessed value of homesteaded property to the percent or consumer price index. That was implemented by the Florida legislature, and it remains today, some 30 years later. It is protecting longtime residents from being taxed out of their property. And the difference between market value and assessed value, because over time, market value has tended to rise greater than the lesser of 3% or CPI, is known as your Save Our Homes benefit, which we'll get into in a little more detail. So here's the last 14 years of CPI. We have posted 2023. So it's only the third time in the last 14 years where CPI has exceeded or equaled 3%, 2012 being the last one before the last 2 years. As we all know, the consumer price index and inflation has been very high in 22 and 23. So, but as CPI is greater than 3%, your increase in assessed value for 2023, if you were already a homesteader, will again be 3%, just like it was in 2022, because that is the cap. If you have a commercial property or a non-homesteaded property, your cap is always 10%. 10% on the assessed value, but market value is what market value is. And for a non-homesteaded property, the difference between market value and assessed value, that is still subject to school taxes. There is no benefit of a 10% cap for school taxes on a non-homesteaded property. There is on a homesteaded property. And anytime there is a transfer of property, all caps reset. Not only a transfer, it could be a death of the owner, of the sole owner of the property. It's sitting in their estate. The homestead gets removed, the cap gets removed because the owner is no longer the homesteader. It's the estate that's the homesteader. So there's all kind. If you apply for homestead for the first time, let's say you've had a vacation home here in Florida for quite some time, and you apply for homestead, that cap resets as well under the law, which is sometimes unfair, sometimes causes you to pay more taxes if you file for homestead. Our office is more than happy to discuss with you the difference between keeping it non-homestead or homestead for tax purposes. Last year, 2022, we saw significant increases in market value, and many new homesteaders who have owned a property for quite some time decided not to because their taxes were less by not homesteading the property. So here's a little bit of how Save Our Homes work. It's a mathematical formula. This particular example shows market value rising at 5%, the Save Our Home cap, the assessed value rising at 3%. So it starts building up a benefit over the years. Now here's an example of that same benefit going out for 7 years. So you can see it started out year after purchase, it goes to market. Assessed equals just value or market value. And then a 5% increase annually versus a 3% cap. You built up about $44,000 by year 7 in the Save Our Homes cap that you are not paying taxes on. You're only paying taxes on the assessed value, less any exemptions you may have in addition to homestead. And that difference is your Save Our Homes benefit. Now, let's say that same home, you sold it in year 7. Year 8, once January 1 crosses, that new owner it goes to market value. You see new owner year after purchase, market equals assessed, less the homestead exemption. So taxes, which were for the prior owner, $6,164, for the new owner are now $9,000. And that comes as a shock to a lot of new owners. But we do have a tax estimator on our website that will let you know what your taxes will be the year following purchase. Year 7, you more than likely inherited the homestead of the prior owner. You have that homestead of the prior owner until December 31st. Once you cross the January 1, you must apply for homestead. It doesn't transfer to you automatically. You have to apply for it. But once you do apply, and because the property changed hands, the just market value equals assessed value. Oftentimes we get this in our office. Well, my neighbor only pays a fraction of the taxes that I pay. Well, here's a perfect example in St. Petersburg. There was a home on the right that was bought in 1993. That home obviously was a lot cheaper in 1993 than it was in 2018. So that started out at a very low market value. And because that property was homesteaded for all that time, benefit of the Save Our Homes cap, that property is only paying in 2020, only paid $678 in taxes. The exact same home right next to it, same square footage, same lot size, was bought in 2018 at a much inflated price compared to 1993. Cap reset. That home was paying $4,400 in taxes. Is it fair? Probably not, but that is the benefit of the Save Our Homes cap. So as long as you stay in your home that's homesteaded, it's a huge benefit to a longtime homesteader in Florida. Now the 10% cap, as we discussed earlier, that is a non-homesteaded property. Your assessed value for tax purposes can't exceed more than 10% from year to year, and never in both cases, whether it's homesteaded or non-homesteaded, can assessed exceed market value. We have seen rising market values and falling market values, and we'll get to an example. But again, the full market value is subject to school taxes. So your school taxes, which in a lot of cases represent about a third of your taxes, you're still paying the full taxes on market value under a 10% cap scenario, where you are not homesteaded, or it's commercial property, or it's owned by a corporation. So the cap remains, again, similar to homestead, as long as ownership doesn't change. If you apply for homestead, as I mentioned earlier, the cap will reset to market value. And anytime there is new construction on any property, that is added over and above the cap. If you add a room to your home, we will take the 3% cap in this case from 2022, add it to 23, and then add the value of the addition for tax purposes to your assessed value.
Question for you.
Yes.
So if I've had 10% cap on a property for a very long time, I decide to apply for homestead exemption, cap comes off, as you just said, and then the market goes up a lot that year. Can I take back my application?
You absolutely can. A matter of fact, we had several dozen people this year. We saw some market value increases from 21 to 22 in excess of 50%. Especially on the barrier islands, waterfront property on the beaches. That was the first year they applied for homestead, and they lost their cap. They were much better off remaining as a non-homesteader, keeping their 10% cap as their taxes were lower. We're happy to do that analysis for you, and provide it to you so you can make the decision whether to keep your homestead or rescind it and then apply in a future year.
Thank you.
So here's a little history of what can happen in rising and falling market values. The blue line is the market value. We saw this in the early 2000s, 2000 through 2007, 2008. Again, market value was going up and up, and then the great recession, which caused home prices to fall. Those market values came back down between '07 and 2012. All along that yellow line, though, if you are homesteaded, you're capped. So no matter what happens to market, you're still only paying taxes at the assessed value. But in year 5, they met, let's say, so market assessed can't exceed market. It rides down with it. And as we've experienced now for 2013 forward, we see another rising market. So you're building up that cap, the difference between assessed and market value. And that benefit, if you choose to sell, you can take with you, which leads us to portability. So that Save Our Homes differential, and you will see that on your trim notice, is the difference between the market value and the assessed value. You are not paying taxes on that if you are a homesteader. And the only portability is available to homestead properties. It is not available to non-homestead properties that may have a cap. You have to be homesteaded. You have to transfer one homestead to another, and there is a time frame. So, again, difference between just and assessed is your Save Our Homes differential. If you sell your home, you have 3 January 1s to reestablish homestead in another Florida property, anywhere in the state, doesn't have to be in Pinellas County, in order to move that to that property. If you miss that window, you've lost that benefit forever. So for instance, let's say you sold in 2022, January 1, and that would be any time during 2022. You could have sold on January 2nd, or you could have sold on December 30th. That first January 1 is 1/1/22. So you have 3 January 1s, excuse me, to reestablish homestead in another property before that benefit is lost. So 1/1/22 would be 1, 23, 2, 24, it would be the third one. So you have until 1/1/25, or actually you have to own and occupy as of 1/1/25 and establish homestead in order to port that differential to another home. And the application must be submitted before March 1st. Excuse me, we do allow late applications beyond March 1st with an extenuating circumstance form. So how is portability calculated? You look at the just value of the home you sold in the year you sold it. You compare it to the new just value of the home you purchased, where you crossed to January 1, the January 1 after you purchase it. So your new just value compared to your previous just value, if it is equal to or greater, you get the full amount of portability that you brought from that previous home, up to a maximum of $500,000. It is capped at $500,000 per statute. If your new just value is less than your previous just value, we call that a downsize. You get the pro rata portion. So if you downsize by 50%, you get 50% of that Save Our Homes benefit applied to the new home. Again, limited to the $500,000 max. And our tax estimator right on our website can compute that for you, whether it's a home here in Pinellas that you sold, and you move to another county, or if you move from another county here into Pinellas, you're able to put in the values of what you had in the other county, and we will compute that for you in our tax estimator as to how much port you get, and then the resulting taxes the year after you purchase. So portability used to be 2 years, or actually a little more than one, depending on when you sold. But Mr. Twitty championed legislation back in 2021 to extend that to a third January 1. So you really do have a full 2 years. So if you sold in right here before, you only had a year and a day in order to establish homestead in a new home. Now you have 2 years and a day. Or again, 3 January 1s. If you have any questions, whether you're eligible for port or when you could potentially lose your port from a prior home, please call our office and we'd be happy to discuss that with you. And the reason that extra year was championed, there are all kinds of reasons why. You sold your home and you're getting a new home constructed, or a new condo building was being constructed and it was late. And it was not unusual for a lot of people with that short window, depending on when they sold this first year, to lose their port. And it's a very valuable asset that you do not want to lose if you certainly can avoid it. Okay, now I'll turn it back over to Alex, and he can go over some common missteps.
I'm our staff attorney here, and we'll be going through some of the common missteps we see related to these issues. So the first big ones we're going to go through are the cap reset issues. One of the number one things that comes into our office is new home buyers are relying on the taxes paid by the prior owner. So if you buy a property mid-year after January 1st, and the seller had the Homestead Save Our Homes cap, then you're going to be paying taxes based on that amount. The next year, as Kevin pointed out, the taxes are going to be reassessed at the market value. So it could be wildly different, as the example we pointed out in St. Pete, with one house paying $600 and the other one paying $4,000 based on the time of purchase. So you can never really rely on the taxes paid by the prior owner. What you need to do is go to our website and use the tax estimator. It'll tell you what your estimated taxes will be based off your purchase price when coming into your new home. So the next one is homeowners transferring their homestead property or even their non-homestead property into an LLC. This will always trigger a reassessment at market value and a removal of the cap. So an LLC does not qualify for homestead exemption. It has to be a natural person or the beneficiary or trustee of a trust. The only time that an LLC can hold the underlying title is if you have a 98-year or greater lease in the property. So this is the big one. If people are trying to estate plan, they want to put their property into an entity to protect their liability. Well, you have to understand there are some tax ramifications, or real property tax ramifications. An LLC is an entity distinct from its members, and the members don't have any specific interest. So if you are a sole owner of an LLC, once the property is put into that LLC, it resets the cap. So just be very wary of this. We see this issue several times a year. We do send out a courtesy letter now whenever a property is transferred into or out of an LLC for no consideration. That meaning if there's no sales price associated with it, we send out a letter notifying the parties that, by the way, your cap is going to reset the following year. Also, as we discussed before, the cap will reset when you apply for homestead. If you had the 10% cap before, you now apply for homestead, the property goes to market value, then the 50,000 pulled off, and then the following year, you would then benefit from the Save Our Homes cap.
Yeah, this is a good time to answer a question. John asked the question. I applied, I went on estimated taxes for 2023. Would I benefit by not applying for homestead? Well, the question is, If you bought the property in 22, John, you definitely would benefit from applying for homestead because your home goes to market value the January 1 after purchase. So you would get the $50,000 exemption off of the market value, which is also the assessed value. If you've owned it for quite some time, let's say you've owned it, you bought it in 2018, and this is the first year applying for homestead in 2023, you may, if you've already applied, that's fine. You may benefit from not having homestead, and we can certainly take a look at that for you. The one thing I need to caution you on, we haven't valued property yet for 2023. So we don't know what the values are going to be. We won't know till probably May or June, the month of May. But feel free to call our office. We'd be happy to let you know what the difference is having homestead versus non-homestead.
And to elaborate a little bit more too, we always encourage you to apply because as Kevin pointed out, you can apply, then the values come out, and you can later decide to just pull back the app.
Absolutely.
If you think that your 10% cap is going to benefit you more, you can just pull the app out, just let us know, and we will rescind your application and put the 10% cap back on.
Absolutely.
So here is the one that we kind of, comedically call the sneaky sellers here. So property owners may request that a homestead be removed from a property being sold prior or after the date of the closing of the sale. So what this means is originally we were talking about how the buyer is going to benefit from the seller's homestead exemption for the tax year. This is an odd situation where the seller may already have another home lined up or already purchased another home to go live in. If they apply for homestead on that other property, the seller that is, they can take their homestead off of the property that you're purchasing and put it onto that property. In Pinellas County, we only allow this up to the deadline, which is March 1st, to apply for exemptions. But if it's going out of county, not every county has this rule. So what this means is that you can be relying on paying those lower taxes the year of your purchase, but if the seller takes that homestead and moves it to their property that they're going to be living at, then you could be on the hook for a much larger tax amount during that first year that you purchase the property. So it's very important to understand what the seller is going to do. And we highly recommend this at the closing table when you're negotiating. Ask, will the seller be keeping their home? If there is a homestead exemption, ask if they're going to be keeping the homestead exemption on the property you're purchasing for the year, or if they'll be removing it. Because you could be in for a shock when the taxes double or triple for your purchase year.
And to add to that, that also affects the proration of taxes at closing. So let's say you're buying a home on July 1, which is halfway through the year, based on taxes from the year before, which are low. If the seller has removed the homestead, those taxes could be significantly higher, and their proration for that half year taxes will be much higher that they would credit you with. So it is really, really important to understand the seller's intentions. Have your broker, have your lawyer, whoever you're using as part of for the transaction, make sure that you are 100% positive about the seller's intentions, which will affect the proration of taxes, the taxes in the year of purchase, and hopefully, if they keep the homestead on, then you won't face new taxes until the following year.
Right. And
sorry.
I can go back. One more thing I'd like to point out on the last slide is, if you still can't get an answer out of the seller or anything, what you can do is check our website. And if the seller had requested the homestead removal, you can see it on our website within a couple days of their request to remove it. So, you can actively be checking our website before you do the sale to make sure that homestead is still on the property and it hasn't been removed by the seller. Okay. Yeah. So renting homestead property. So in Florida, to keep your homestead exemption, it has to be your residence. So short-term rentals are becoming a bigger thing here. The rule related to renting your homesteaded property is that you cannot rent the homestead more than 30 days in 2 consecutive years. So you can rent your property for 28 days, but as soon as you hit 31 in 2022 and 2023, the homestead you're no longer eligible for homestead exemption. If you don't notify our office that you have been renting your property for greater than 30 days in 2 consecutive years, it can lead to a very hefty penalty. So the statutory penalty and interest is 50% of the undeserved taxes plus 15% interest per annum. So that can be a lot. If you have a lot of Save Our Homes cap, you're going to have a 50% penalty on that plus 15% interest. It can be a very hefty lien. So what we always ask is that on that renewal form that goes out every year on your homesteaded property, please let us know if you're renting the property and the length of rental so we can determine if you're still eligible for homestead and you can avoid getting hit with a very large lien.
And it is a lien if in fact it goes unpaid, and to avoid a 50, that's 50% penalty, and 15% interest. If you disclose it to us, we will waive the penalties and interest. If we find out from you that you are renting and you have told us you're renting, we can remove your homestead. All that does is change your taxes for the current year. But if we find out from a neighbor who's not happy with the parties that are happening when people are renting your home and all the noise in the neighborhood, and it's been going on for years and years and years, that is one hefty penalty. We don't like doing it, but it is state law, and we're required to do it when in fact it is a violation of the homestead law. So I have a question here. Let me see if I can move up here in the chat. Okay, sold home during divorce. It was homesteaded in both names. Purchase home following year alone. Can one person use the portability? The answer to that is yes. However, there is a form that is required to be filled out. It's the 501 TS.
Yes, that is correct.
TS form, which lets us know that the parties who both had homestead during the marriage agreed to give 100% of the portability to the other party. It has to be signed by both parties. Otherwise, if it's not, you're entitled to 50%.
Correct.
You get 50% of the portability. But okay, again, renting, would that apply to renting a room in your home?
No. So if you have a roommate or are renting, a portion of your homesteaded property, that does not make you ineligible for homestead. You need to be renting substantially all of the property. And so, if you're renting 90% of the property and you're living in a garage area with a kitchenette or something, that is substantially all, and that would make you ineligible. But if you just have a roommate with you, then you can still continue your homestead uninterrupted. And we do encourage people to reach out to us if they are doing that, just to let us know, because in the event, as Kevin pointed out, a neighbor calls and says, these people are renting it, then we have to investigate, and that's never a nice process. But if you tell us, hey, I have a roommate, then we can just note that and be on with it.
Good point. Good questions. Thank you.
Thank you.
Oh, I gotta go back here.
Oh.
There we go. Oop.
All right, so changes to the deed. This is another big one for common missteps. The do-it-yourself deed, never advisable, because if you report a deed that changes the type of ownership of the property, it can affect your homestead exemption or non-homestead exemption in a lot of ways. For example, if you own a property 100%, and you have homestead on 100% of the property, you are trying to feed the property to, let's say, yourself and your son, or your sibling or whoever, for estate planning purposes. So you want to do it with survivorship rights. So when you pass away, you can avoid probate and grant it to them. Well, when you did the deed yourself, you left out the survivorship language. Now, the default tenancy in Florida is in common, which means you share it. So now you own 50%, and whoever the second person was owns 50%. And guess what? You lost half of your homestead exemption and save our homes cap, because you're only entitled to what percentage you own of the property of your homestead. This is a very big mistake we see all the time. So we always recommend people, before recording deeds, to contact our office if you have homestead exemption and you're concerned about the effect that recording a deed or changing ownership may have on your taxes. You can always ask us. We'll be happy to review any deeds you plan on recording to let you know what the tax impact would be on your real property. So the examples below, adding a name, that's one of the biggest ones that we ever see affecting homestead. The next is putting the property into LLC, which we touched on. That will reset your cap, whether it be homestead or non-homestead. For putting property into a land trust or any form of trust, this is another one that's a little tricky. So Florida law says that a trustee of a trust will always be entitled to homestead exemption. But a beneficiary of a trust requires some very specific language in order to qualify for homestead exemption. So if you put property into your trust where you're the beneficiary and not the trustee, but the deed is silent as to what interest you have as the beneficiary in the real property, then you'll get a friendly letter from our office requesting a copy of the trust so that we can review it. As a beneficiary of a trust, in order to qualify for homestead exemption, you must have two things. You need to have the present possessory right in the property and a equitable or beneficial interest in the real property. These two things must be satisfied in order for you to claim homestead or continue to claim homestead as a beneficiary of a trust. This is not something that's usually thought of at the drafting process by the attorney. They're more concerned with how will we distribute the assets and what will happen when people pass away, because it's usually an estate planning device. But if you want to maintain your homestead exemption, that language needs to be in there for the beneficiary to claim the homestead exemption. And then one more thing is the land trust specifically. If a land trust says that the beneficiary's interest is personal property, you cannot claim homestead exemption. That language is binding for all determinations under the law, and you must have a real property interest to claim homestead, not personal property. So, please just contact us before you make ownership changes if you have homestead and you want to know what the tax impact will be, because the January 1st is the assessment date in Florida. So if you make these changes on December 29th, once January 1st rolls around, there's nothing you can do to roll back or fix those changes, and it may affect your Save Our Homes cap or your non-homestead cap forever going forward.
Okay, a good question here from Miss Walker. How can you change the deed? I added my son. Well, it depends how you added your son.
Correct.
Alex?
So if you added your son as joint tenants with rights of survivorship, then technically under the law, you both have 100% ownership of the property, and there will be no change to your homestead. If you added him on as a tenant in common, where you both own 50-50, then that will affect your homestead exemption. So feel free to if you want us to review the deed or let you know what the impact will be, please send us an email or call us, and we will do that. But if you added your son on and it's now 50-50, usually, we can't really tell you how to fix the deed but we can let you know what the ownership would need to look like for the homestead to be 100%. So if you own it 50-50, then a new deed from both parties would have to be recorded with the clerk of court, changing the tenancy to a certain form that gives you both 100%, whether it be joint tenants with the right survivorship, a life estate, or some other means where you maintain 100% ownership for the homestead exemption.
So yes, you can change it, but it can't change the past. Once, as Alex said, once it crosses January 1, there's no way you can backdate a deed to say, oh, I made a mistake. Everything in our world goes off of January 1. But if you wanted to get it back to 100%, for the next year, that deed must be filed before December 31st of 2023, and it can revert back not necessarily to the taxes you had before the initial change of the deed, because once that deed changed ownership, you also lost some of your Save Our Homes cap. So hopefully that answers your question. And and down at the bottom, we say, have your clients contact us before making deed changes. We get questions all the time in our office about, well, what's the wording of the language have to be? What do I have to do? We cannot give legal advice. We always recommend that you contact an attorney and then have the attorney reach out to our office to say, is this language okay? Will it affect the homestead? And we're happy to opine on that, but not the deed itself and the wording in the deed. Okay, just a quick touch on, as we're about 10 minutes away, and again, thank you for the questions. But there are a myriad of other exemptions that are available to those who are homesteaded. We will be addressing those in our next public education session, Thursday, February 9th from noon to 1. Most, if not all, of these exemptions relate to age over 65, income below a certain income threshold, or a disability of some sort, whether it be because of serving in the military, or serving as a first responder, or just another disability unrelated to either one of those situations. Also, to point out here, the widower disability, the regular disability for non-veteran, non-first responder, in the past was a $500 exemption. In 2023, which then a $500 exemption is at your millage rate is worth about $8 to $10 a year. The legislature finally changed it to a $5,000 exemption for 2023 forward. So now it's a little more meaningful at $80 to $100 a year. That automatically changes if you already had those exemptions. We have moved it from 500 to 5,000 for 2023. There's nothing you need to do, but we'll address all these. There may be some that you qualify for. We'd like you to join us on February 9th for another one of our sessions, and hopefully we can get you. Our goal is to get you every exemption under the law that you're entitled to. You deserve that as a taxpayer, and we will help you get there if you do qualify. Couple more items to touch on. As you know, we were very, very lucky with regard to Hurricane Ian. We were right in the path, but unfortunately for the people south of us who suffered the devastating destruction, we were spared. But there is relief from property taxes for any home that was damaged by Ian or Nicole. And there may have been some here in Pinellas County. And but you had to had your house have been rendered uninhabitable for at least 30 days due to either one of those events. If that is the case, there is a form you can fill out, and a refund will be provided for the portion of the year and the portion of the value change for 2022. And we had this in the past with prior hurricanes. If you have any questions, we're happy to answer them for you, to give us a call. But DR 5001, located on Department of Revenue website, we will need documentation with regard to damage if you did suffer some. There's also under the law, and it's been around for quite some time, called the calamity provision. We hope none of you ever experienced this, but if your home, for instance, is destroyed by fire, in the past, if your home, let's say in 22, in February of 22, your home was totally destroyed by fire, you still had to pay the full tax bill for all of 22, including the value of your home, which was a bit unfair. Well, that law has now changed going forward. If you suffer a calamity or a catastrophic loss in 23 and beyond, you will receive a tax refund for the portion of the year that you're unable to enjoy your home and the value of the home being removed. So you would only pay for land value, in effect, for the portion of the year that your home was destroyed. That is a really nice change in the law. It makes sense. And if your home is damaged by a calamity, you can rebuild that home. In the last bullet here, up to 100% of the square footage that was burned down without adding any more to your assessed value. So if your home was destroyed, let's say the value of the home on the lot was $100,000 and it was 1,500 square feet, it's going to cost you a lot more than $100,000 to build a 1,500 square foot house these days. But when done, if that square footage is less than 1,650, which is 110% of 1,500, we'll put it back on for only $100,000, no matter what the cost of the construction was. So that is the benefit of a calamity. That has always been the provision in the law. And until it's done, you're only paying taxes on the land. You do have a certain time frame in order to permit a new build of the house. You can leave homestead on that property, but it can't be forever. I believe the law is roughly 3 years you have to get it permitted and construction has to start. Okay, stay in the know, follow the PAO. You can find us on Facebook, YouTube. You can sign up on the website for newsletters, homeowners, real estate professionals, business owners, and anytime you can attend one of our in-person or virtual public education sessions. They are posted on our website. We do send out email blasts to our citizens with regards to some future events. So please be on alert for these if for interested topics of yours. Again, upcoming programs, again, personal exemptions on February 9th, and then property tax process for businesses, and then the new website, which we are very close to launching, www.pcpao.gov. Will be coming out very shortly, and we always hold a session for first-time Florida homeowners late in the year, so you're well prepared for what you're about to face when it comes time for a tax bill. And we always end with this because this is an extremely valuable service, the Property Fraud Alert Service. Some of you may have read, and some of you see in the paper all the time, deed fraud is a problem. There are people who try to steal your property by filing a deed in their name. Most times they take advantage of our senior citizens who may be in a nursing home or may be in an assisted living facility and unable to be in their home, where they just go ahead and file a deed and make them, the thieves, the rightful owner. Anyone can go to the clerk's office at propertyfraudalert.com and register their name and property. And anytime there is a recording of any type of instrument in a name, your name, or a name that's very close to you. I did this as soon as I found out about it, and my name is Kevin McKeon, middle initial J. I get alerts if there's a Kevin P. McKeon, if there's anything close to my name. And if you have any work done in your home that requires a notice of commencement with regard to a permit, those get filed as well. So it's a very valuable service. It's free. Please take advantage of it because it's a very useful tool, because anytime anything is filed, you will get an alert on your email. So that is all we have for today. We thank you. Wow, and it's 2 minutes to spare.
All right.
So we're happy to answer any questions that you may have. But again, we appreciate you joining us. Hopefully you got something out of it. And again, we are always available at 727-464-3207 to answer any question you may have with regard to your property value, your exemptions, or your property taxes. So given that, I don't see any further questions out there. So thank you for your attention, and we look forward to seeing you at future events. We appreciate it. Bye-bye now.